Hi, good evening all. This is a short video of my seminar presentation on the topic the Employees Compensation Act 1923. In this video, I'll be trying to explain about the history of the act as well as how this act was formed. Also, some main features of the act along with some important sections of this act. So, first, let me tell about the history of Employees Compensation Act and how the act was formed. The Employees Compensation Act 1923 was enacted by Government of India. We all know the Industrial Revolution was happened in the first half of 20th century as well as the fourth quarter of 20th century. So the invention of the steam engine was triggered the Industrial Revolution. Along with the invention of steam engine, the whole world were mechanized and the whole factories in this world were mechanized. The factories in the world were installed with modern machines. One thing we have to notice about these modern machines is the modern machines were very dangerous. It was very early for the people who invented those machines to think about the security measures which they have to provide to the persons who were handling these machines. So obviously, we can think that the persons who are handling these machines were the workmen or the employees who were working in these factories where these machines were installed. So lots of injuries and accidents occurred to the workmen who were handling these machines. As a part of it, there was a huge pressure on the employers from the part of the workers to give them protection or to give them security against these accidents happening in these machines. So in India, in 1885, government of the then government of India, there were Britishers enacted an act called Fatal Accidents Act 1885 to protect any persons who attaining an accident. So, in the light of these accidents in the factories, even the legislators who made the Fatal Accidents Act, also the government of India felt that the Fatal Accidents Act 1885 was not sufficient to fulfill its purpose. So, in 1910s and 1920s, the government of India decided to constitute a committee comprising of the legislatures, the representatives of the workers, the representatives of the employers, as well as some expert in the fields of medicine and insurance. And the government of India asked the committee to file a report on how to protect and how to enact any laws for protecting these employees or the workers. So the committee along suggested gave the government lots of suggestions. One among them is to enact an act which ensures compensation for the workers who is suffering any injury from the employers. So, thus, the government of India in 1923 enacted an act named the Workmen Compensation Act 1923. Or later in 2010, the Indian Parliament amended the Workmen's Compensation Act 1923 and renamed it as the Employees Compensation Act 1923. So that's for the history. Now let's go and let me explain about the main features of the Employees Compensation Act as well as the important sections of the Act. The purpose of the Employees Compensation Act or the aim of the Employees Compensation Act is to provide payment as compensation to any person who are working in a factory who suffered an injury from the side of the employer. Employer. The next is an important section. It's called Section 3 Clause 1. In under Section 3 Clause 1, I'll read the section. An employer is liable to pay compensation if if a personal injury is caused to an employee by accident arising out of and in the course of employment. That means an employer is liable to pay compensation to an employee who is suffering an injury, who is suffering a personal injury during his course of work. And that one thing we have to note that there is some conditions uh, recognized. There are some conditions for an injury which has to be recognized in this act. An injury shall be permanent and it shall be partly or completely on the laborer, and also the injury shall be last at least for 3 days. And the next is section 2 clause DD, that is the definition of employee under the Employees Compensation Act. There are four categories of persons who comes under the definition of employee under Employees Compensation Act in section 2 clause DD. The first thing is the railway servants who is not permanently employed under the Indian Railways. Uh, The next category is the crews of the ship or aircraft under any company registered in India. The third one is a driver, helper, or mechanic of a motor vehicle or any person who sent abroad by a company who is in which is in India. The fourth category is a long list. It says that any person employed in any capacity as specified in Schedule 2 of the Employees Compensation Act. The Schedule 2 of the Employees Compensation Act is a long list which comprises of 50 categories of people who is employed in any capacity. So it specifically mentions that, or it specifically excludes the persons who is working for Indian Armed Forces from the definition of employee under Employees Compensation Act. That means the compensation getting by an army man from his employer is not comes will not comes under the Employees Compensation Act. So also let us know that the name of the act were the Workmen's Compensation Act. Obviously, the definition of workmen was included in the Employees Compensation Act 1923, and in the amendment of 2000, the term workmen, the definition of workmen were omitted from the Employees Compensation Act, and the definition of workmen is much similar to the definition of the employee in the employees under the Employees Compensation Act. So next is section 4. It is the mode of computation of the compensation. The compensation of a person which have to be given by the employer to any of their employee is computed or is calculated by considering the degree of the injury suffered by the employee. If the person is died or the employee is died during the course of his employment, the compensation shall be given to the dependents of the employee. So next is section 3 clause 5. Section 3 clause 5 is an important section which limits an employee from getting a compensation. The two limitations which has mentioned in section 3 clause 5. The first one is if a workman is accepting any compensation from the employer, after that he cannot go before the Commissioner for Employees Compensation for getting further compensation. I will explain about the Commission for Employees Compensation later. And the second limitation is if an employee suffers an injury and goes before any civil court who has jurisdiction in India, he cannot, after that, he cannot file a petition or he cannot institute a complaint before the Commission for Employees Compensation for getting compensation against the employer. So the next is an important section, that is section 9. In section 9, it made that the compensation which were given to the employee is protected against the attachments by any legal procedure. For example, I am an employee who suffered an injury. Also, I have some liabilities to any other person, and he cannot file a suit or execution petition in a civil court that to execute a petition in a civil court to attach the compensation I got from my employer to him. So the compensation which were given to me is protected against any legal attachments. So next is section 20 clause 1. Here the in section 20 clause 1, the commissioner of employees compensation is recognized. The government has to appoint a commissioner of employees compensation, also the commissioner for employees compensation. And the importance of commissioner of employees compensation comes under now. Before that, I will tell the duty of commissioner for employees compensation. The duty of commissioner for employees compensation is to resolve any dispute between the employee and the employer for giving any compensation, or between the employers or between the employees for giving or getting the compensation. So the importance of commission for employees compensation comes under this. That is, usually an employer can give compensation to his employee directly, but in some cases, such as if the death or permanent disablement happen to an employee, the employer cannot give the employee compensation directly. It is because in these cases, or death or permanent disablement, the compensation will be going to the employee's dependents. This because if the person is died, that person that cannot be given the compensation directly. Also, if the person permanently disabled, he cannot go and collect the money because his whole body is gone. He cannot go to the employer, or he cannot go before the commissioner for employees compensation and get money. The money will directly go to the dependents of the employee. So there can be dependents who with a bad intention or bad mind to misuse the employee, the compensation gets getting for him. The person is permanently disabled, the we cannot, the state or the employer cannot give to his dependents who is not willing to take care of that person, or who is not willing to spend that compensation in the interest of the employee. So the act made sure that the employee, the compensation is given to these persons who died or suffered an injury made him permanent disablement, shall be given through the commission for employees compensation. The commission shall decide on the merit to whom to which dependent this compensation shall be given. And finally, it is the section 30 clause 1. The commission for employees compensation will be giving award against employer or against employee. There will be a person suffering any there will be persons, or there can be the employer or employee to against whom the award is given. So that person can file appeal against this award. The appellate authority is the concerned high court in each state. So the employee or employer against whom the award is given by the Commission for Employees Compensation, that person can go before or file a suit before the high courts of that state as an appeal. So that's it. Thank you for everyone who patiently watched my seminar. Thank you, ma'am. Thank you.